Hello and welcome to the debate. I'm your host, Sana Maqbool, with you at BTB World. In today's show, we're going to be taking a look at the current political situation of the country with a particular focus on our first segment with regards to what is going on in KP and, of course, the talk with regards to the KP Assembly session and conversations around the governor's letter, which a number of people have talked about is something that he doesn't have the authority to do so. The KP Assembly Speaker and, of course, the government in the province has argued that the governor cannot call for a session of the KP Assembly, and this is something that they have then, of course, moved the law department with as well in terms of requesting advice as to how to move forward with this situation and what really is going on. At the same time, we've also seen that the opposition parties have also said that they're going to go to court and to the Election Commission of Pakistan for the KP Assembly session to be held, particularly, of course, with reference to the oath taking of the MPAs on minority and reserved seats. And these are important, especially with regards to the Senate polls next month. And so we're going to be taking a look at what exactly is the legality of this matter and what is really going on and why is it that the situation is being talked about in terms of the fact that the governor does not have the authority to do so, and what he has taken, the step that he's taken is an illegal one and that requires action, and that there needs to be a discussion as to how to move ahead. At the same time, it's also being discussed that perhaps it is the PTI's interest to delay the oath taking of the members on the reserved seats because of the numbers that, of course, will then affect the Senate polls as well. So we're going to take this into account and try to understand what really is going on and what are the legal steps moving ahead. In our second segment, we will be focusing on the fight against terrorism. Pakistan, of course, has reiterated this on various platforms and has said so once again that they're all for dialogue and cooperation, particularly in terms of counterterrorism activities with Afghanistan, and this is something that both countries need to cooperate on. However, it does require the support of the Afghan Taliban in Afghanistan, and if that is something that cannot be guaranteed, if they cannot protect that their territory is not going to be used against any other, then Pakistan will be forced to take action, such as the air strikes that were conducted recently on terrorist hideouts in Afghanistan in response to a terrorist attack that occurred in North Waziristan in Pakistan on March 16th. And so this is important, especially in terms of what lies ahead and how we're going to be navigating future counterterrorism efforts. The defense minister has also talked about the possibility of ending the trade corridor that Kabul enjoys with India through Pakistan, something, of course, that he has said is an option for Pakistan to exercise if Afghanistan does not provide the kind of cooperation it needs on the counterterrorism front. So we're going to be talking in detail with regards to that in our second segment as well. For this and more, as always, in the studios, I've been joined by senior analyst Farrukh Pitafi and Raja Faisal. And for our first segment, we've been joined by Mr. Nouman, who is Advocate High Court, and Barrister Shabbir, Advocate Supreme Court of Pakistan. Thank you very much, gentlemen, for being part of the discussion. I'll start with you, Mr. Nouman, with reference to, of course, what is going on with, of course, the discussion around what the governor has done and the step that has been taken in terms of whether or not he had the authority to do so or not. If you can also shed light for us exactly what is the problem here and what authority does the governor have in terms of the assembly session.
Session of Provincial Assembly with regard to taking oath of members on the reserved seats. With regard to the jurisdiction, the powers that the governor have, whether he can call for the session or summon the session of the Provincial Assembly, that isn't positive because Article 109 of the Constitution of Pakistan of 1973 is very clear on that the governor have the power to summon the Provincial Assembly. If we read it with Article 110, that says that the governor have the power to speak to the provincial assembly and merely to speak to the session of the provincial assembly. For that very purpose, he can also summon a session of the provincial assembly. So it is very clear, it is in black and white that the governor have the power to summon a session. And how it is being disputed by the Sunni Ittihad Council, rather the PTI, is that because for now the reserved seats they are of immense importance because PTI or Sunni Ittihad Council enjoys a great majority in the provincial assembly of Khyber Pakhtunkhwa, and for that very purpose, in the Senate election, they are expecting that their own members would get elected. So if the reserved seats are given to any other political party, as it is very expected, because the Peshawar High Court decision did not go in their favor, and it is yet to be adjudicated upon by the Supreme Court whether these reserved seats would be given to Sunni Ittihad Council or not. So what happens now is that in case the reserved seats are given to any other political party, and thereafter election to the Senate takes place on those seats that have been given to other political parties because Sunni Ittihad Council is not entitled to them, then it would create an ambiguity, rather a very big constitutional issue and a very big problem for Sunni Ittihad Council and PTI, because doing it would not be that complicated, but undoing that would be a very complicated process, and they would have to go to the election commission and the election tribunal in order to undo that. Now, what is being argued by Sunni Ittihad Council and the speaker and the party members is that the speaker have the prerogative to summon the provincial assembly. But if we go to the constitution and we see that the speaker only have the power to summon a session only if 1/4 of the membership of the provincial assembly writes to the speaker that they want him to summon the session of provincial assembly. This was further interpreted by Peshawar High Court in case of Baldeep Kumar, that is reported in PLT 2018, Peshawar page 113. It says that it's very clear, it's very beautifully interpreted that the governor have the sole power and exclusive power to summon a session of a provincial assembly, and the speaker only have power to summon session of provincial assembly only if 1/4 of the membership of that very assembly asks him to do so. So it is merely being used as a delaying tactic so that they can buy themselves time, the Sunni Ittihad Council, so they cannot lose on the reserved seats and the Senate seats that are connected with the Provincial Assembly of Khyber Pakhtunkhwa. So I think
Right.
the opposition are also planning to take a petition to the Peshawar High
Right.
Court on Monday, they have announced.
Right, and I'll come back to what the opposition wants to do and what options they have. But Barrister Shabbir, if you could also shed light on this again in terms of what is being discussed as a difference in terms of requesting a session and actually calling for a session, that this is what the governor can actually do is request the speaker and not actually summon it. And if it is so clear that this is something that the authority that the governor has, so where is that grey area in which the PTI or the Sunni Ittihad Council is playing for this delaying tactic, as Nouman Sahab was saying earlier? If it is so clear, why is it that this is happening in the first place?
And could you also help us understand, if your answer is yes, that it is a matter of black and white, what is the rationale behind empowering the governor rather than the speaker?
You see, the literal interpretation of Article 109 of the Constitution is that the governor has the power to summon the assembly and or to prorogue any session. But when we read Article 109 with Article 105, as is the case for the president in exercise of his powers vis-a-vis the prime minister and the cabinet, it is well settled that the governor has to act on the advice of the chief minister. He cannot on his own literally, I mean, if we were to interpret Article 109, call the session. But that is one aspect of the matter. I mean, obviously I have to respond to the other question as well. But I see that this issue has three dimensions. One, of course, is the legal dimension. Then there is a political dimension. And then later on is also as to which one would say is whether what is being done is ethical or not. So legally, on the face of it, even if the governor doesn't have the power, the problem that I foresee is, let's suppose the assembly is called, and assuming that the governor has the session, has the power, the quorum would not be complete. And even if the speaker, let's suppose the speaker calls the session, and the PTI or Sunni Ittihad members, they decide to remain absent and they don't go, the quorum at present, which has to be 1/4, and if it is not 1/4, the constitution also requires that the session be adjourned. Now, what happens in that situation? It appears to be a rather a deadlock. I haven't done the numbers, but the experts sitting on this show may calculate. I mean, I'm not sure if these 24 reserved seats, first of all, would be included in the quorum or not. And if they are not, the earlier seats of the others which do not form part of Sunni Ittihad Council, they are not even 20, I would say. So would they constitute quorum because they are not one-fourth? And if the quorum is not complete, irrespective of whether the governor calls the session or not, even if the speaker calls the session and the members choose to remain absent, there's nothing you can do about it. I mean, these are proceedings of the assembly, which also cannot be called into question before any court. There is a constitutional protection given to it. Because my opinion, first of all, and also our discussion, because end of the day, PTV World has a very wide coverage. Our duty, first of all, is to give you a legal opinion based on not just this one scenario. Remember, the interpretation of the Constitution has to be for all times to come. Today, for one instance, if it suits one party, and if we were to say that no, the governor can or cannot call the session because tomorrow anybody else would be there. So I think in the present scenario, even if the speaker were to call the session, the deadlock would remain. The court can, like the court did in the previous situation when the speaker of the National Assembly had passed an illegal order. And the Supreme Court had struck down that order, although these were proceedings of the Assembly. But in certain situations, the court can interfere. The last point that I wanted to make was with respect to the political aspect. I think it is, one would say it is unethical, because if the reserved seats are there and Peshawar High Court has also decided against Sunni Ittihad Council, then preventing members to take oath, one may even term it as unethical. But is it a good political move? I don't think it's a bad political move, because given it's tit for tat, given and a little one, because given what you've been doing to Sunni Ittihad Council, I don't think in the realm of political arena, it is as such a bad move on their part.
Right. I just wanted to actually ask about what you were saying regarding various scenarios. And those are important, but they are essentially hypotheticals, right? And the question is whether a court that is going to take cognizance of the matter, is it going to take into account hypotheticals also, or counterfactuals for that matter, or are they going to decide basically on the basis of the word of law?
No, but suppose if a petition is filed before the Peshawar High Court, in our legal language, I think a writ of mandamus can be issued by the High Court, directing the speaker to convene the session, directing the speaker to do what he's otherwise by law required to do. But I think it's not an easy matter, because calling of the session is the business of the House. And at this point in time, it may seem that it is important for Senate elections, but end of the day, it is still the business of the House. And if you once allow the court to interfere in the business of the House, then tomorrow there may not be any end to it. So therefore, I don't think it is too straightforward a matter that the High Court will intervene and will direct the Speaker to convene the session. But there is another way out, and which ideally, if I were engaged, I would have opted for. But since I'm a regular on your show, I would disclose. I mean, on 3rd of April. All of this is happening for Senate elections, all right? Often the High Court can grant a stay. So if you file a petition, irrespective of whether that is maintainable or not, the High Court can pass, the Peshawar High Court in this case, can pass an interlocutory order that up until this petition is decided, the Senate elections for Peshawar, for the Peshawar MPAs, may not be decided. These seats may be put on hold because end of the day the fight is on these 24 seats. So such a restraining order can be passed. I'm sure that the Provincial Assembly of Peshawar cannot for all times to come remain idle like this. So I think this move can be defeated by a restraining order because we don't have much time. I don't know if the Peshawar High Court can decide in 10 days this dispute.
Barrister Shah, by Peshawar MPs, you mean Khyber Pakhtunkhwa MPs, right? Because
Yes,
these yeah, please.
I stand corrected. In the legal language, we refer it as PHC. Okay. Yes, sir.
Nouman, I wanted to obviously, come towards you regarding if we obviously, look for the reserve seats matter. We know that Sunni Ittihad Council, it actually went to the Peshawar High Court and they did not get a desired result from there. I just wanted to know what is the status of that. Did they actually go for appeal in the Supreme Court? And if so, then wouldn't it be a matter that can be considered as sub judice? And if it is so, then in that case, regarding calling for this session, do they have enough grounds on the basis of a matter that is sub judice that they should not be obviously going for a session for, especially for the oaths of reserved seats and all of the female MPAs and minorities MPAs? They can't take their oaths unless that matter is cleared from the Supreme Court.
And could you clarify that, whether being sub judice also means that there is going to be a stay on the matter? Yeah. Or with appeal, there can be a scenario where there is no stay. So the parties in question are free to do whatever they want.
Before going to the question, I would like to clarify one thing. As Barrister Saab said that a quorum is required for the session. I would respectfully disagree, rather differ, not disagree with respect. The session is being called merely for giving oath to the people, rather the members on the reserved seats. It's not a session for legislation. So the quorum is mostly not considered. Rather, constitutionally, it's not required for giving oath to a member. Furthermore, the one more thing is that the KP procedure and conduct of business rules 1988 that does not give powers to the speaker to summon a session, because that is actually what the whole provincial assembly goes by. Now, coming to the question that was put forward with regard to the status of the case, when Peshawar High Court refused to give relief to the Sunni Ittihad Council, obviously they opted for CPLA to the Supreme Court of Pakistan, but that is sub judice. And when we say sub judice, very beautifully put, whether it means that a matter is to be put to stay and they don't have to do anything. It's not like that. In order to stop the matter, they have to specifically take an interim order from the Supreme Court of Pakistan to stop the issues. For now, there is no interim relief. There is no stay order by the Supreme Court of Pakistan. Therefore, the Provincial Assembly, the governor, the members, they are free to do whatever the mandate of law calls for. And the judgment rendered by the Peshawar High Court, the judgment, rather orders and notifications of Election Commission of Pakistan with regard to reserved seats that went against Sunni Ittihad Council, they remain in force until and unless suspended by the August Supreme Court, or if they ask the Provincial Assembly to maintain status quo. So merely a matter being sub judice before a court, it does not mean that the parties are stopped from doing anything that is the subject matter of the case.
Right. Nouman Sahab, also add to that with reference to, of course, the Senate polls and, of course, the matter to be looked at in light of that as well. I want to know, of course, when we talk about any provincial assembly and the timeline that exists for the session to be there, or for the oath taking of particular reserved seats to be taken on board as well. What is the time frame that we're looking at, and how far can it be pushed as well? Even if we talk about any restraining order, how far can this be pushed before it absolutely has to be undertaken?
See, the time frame, I think it cannot be considered at this moment, because we are far behind, rather, completely not abiding by any time frame that is provided for by the constitution or any other law.
So
You
is,
see,
is that not a problem if we're not abiding the law? Is that something we can just state and be okay with?
it is a big problem. But like I said, these are special circumstances, and in special circumstances, there are new things are to be followed. There are new procedures, and when they go to court, and they had an interim order with regard to the oath being given on the reserved seat by the Peshawar High Court, so they were stopped for a certain period of time till that was decided. But now, when the session is being called by the governor, it cannot be adjourned. Rather, it cannot be delayed any further, because now they have made the session that was called. They made an excuse that members of the Provincial Assembly were not informed with regard to the session. So that means that it is the governor and the whole law is being played with, and the letter by the governor with regard to summoning of the Provincial Assembly that have been stepped upon. So there is no legal time frame, rather constitutional time frame, that can govern and enforce that this is to be done in a particular time, because now everything is past the time that have been given by the constitution, and it is for the courts to decide if it is to be, if the Provincial Assembly is bound. Now, if the Senate polls are uh, I think scheduled for 2nd of April, it is mandatory by law and by the constitution that the every single member of the Provincial Assembly or the National Assembly, they must have taken oath by the time when the Senate election takes place, because each and every vote matters there. And for now, we do not have any oath, rather any Provincial Assembly members on the seats of minorities and the women, that is the reserved quota, which is a big problem. So it is a constitutional issue that we have to deal with, and it is for the High Court to decide if they have to go for the election. Like the opposition had announced that they are filing a writ petition on Monday, and we already have an example, like I said, the Baldeep Kumar case that is decided by the Peshawar High Court against the PTI government that we had in 2018.
Right, Nouman, so let me put it this way. So in any circumstances, it is absolutely a necessity that this matter has to be resolved before the Senate polls?
Exactly, because the voters are the members of the Provincial Assembly. So if we do not have voters that have taken an oath, they cannot vote. So it is mandatory by the Constitution that the voters need to be registered first. The voter needs to have an oath in order to vote.
I understand, sure. Barrister Shabbir, I'd like your take on that as well, especially with what Nouman Sahab earlier said as well. And he talked about how the law is being played with, and I would assume that there are penalties for playing with the law. And so I want to understand what exactly is the accountability here, and who's really accountable, if this is something as per Constitution mandatory, as what Nouman Sahab was saying, or if this is something that the law is talking about as an absolute necessity but is not being done. Then what are the accountability factors here, and who all are involved?
You see, before I go to accountability, obviously this would not be a case previously also when the speaker had passed an order, the Supreme Court had set it aside when the assembly was being dissolved. It is not a case of Article 6 or treason. It is not where you are to be punished. These are political matters, and political arena is the assembly for that matter. Ideally, these matters should not even go to court. But the one important aspect I must say, that what is the justification that the other side has for not calling the session? That is where the weakness lies. I mean, for example, if you ask the Chief Minister of KP or any member of the ruling party there, that why would you not call a session? What is their answer? I mean, or let's suppose the governor doesn't have the authority. What prevents the speaker KP to call the session? I would be enlightened if they have a justifiable cause. Politically, that is their tat for the tit. But otherwise, there is no justifiable cause. And assuming if such a matter were to be, or a writ were to be accepted by the court, then they will have difficulty in justifying their case for refusing to call a session for a lawful purpose, which is that those who have been elected on the reserved seats, why are they being prevented from oath? But Nouman Saab, I wanted to put forward with respect my opinion on the session. I mean, it could become interesting if we don't call it a session. What else do we call it? I mean, you yourself a number of times mentioned that the governor has called a session. I am looking for words. If we don't describe the oath-taking ceremony in the assembly a session, what else do we call it? And if it is a session, then Article 55(3) of the Constitution is very clear. It says that in a session of the National Assembly, for that matter, and Article 127 says that all that is being referred to for the National Assembly would be referred to and for the provincial assemblies. So if 1/4 is not present, it is up to the speaker and he shall adjourn the session. So, I mean, I would stand educated if, we were to create an exception for this very purpose and say that, well, it is not a session but something else. I mean, I'm not saying that I'm right here, but an interesting interpretation could come out of this, that if we don't refer it to as a session, but what else do we refer it to?
When I said session, I said session
Yes, go
for
ahead.
purpose of legislation. That is what I said. So,
Session.
first, session for the purpose of legislation. In order to put a bill forward, it must be the 1/4 of the membership must be present. But for purpose of oath, it is merely the governor that has to be present and the member. Now, as you said, that one other thing that I would like to clarify is that I believe by having, as you said, there are 20 members of the provincial assembly. By that, it is very evident that the opposition have 1/4 in the provincial assembly, because it's a very small assembly with a very meager number of members of the legislative assembly. So I believe they have a 1/4 majority not majority, but 1/4 of the total number of members in the provincial assembly.
Yeah, Barrister Shabbir,
That's a separate point.
Yes, go ahead.
Go ahead,
Sorry.
please.
May I, with respect, I say that's a separate point and an interesting point, whether they have 1/4 or not. And rather more interesting would be that those who have been notified by the Election Commission, although they haven't taken oath, should they be considered part of the quorum or not? And that could be another interesting point. But with respect, if we look at Article 55, it does not restrict the 1/4 quorum requirement for the purposes of legislation only. Session includes each and every session. I don't see where and how we are limiting that power, which is the constitutional power, for the purposes of legislation only.
See,
We don't have
these have been
wanted to put that point across.
exactly. These have been specified. Like I said, there's a KP procedure of Code of Business of 1988 and 1985. So when we say that what is for legislative purpose and what is for the purpose of oath, so for the purpose of oath, the quorum is not relevant, because if you see look at the quorum, so that is the people that are involved in that session. So for the purpose of oath, nobody's involved in that session. It is merely the governor giving oath to the members. So if we say that for the purpose of quorum, somebody have to object to it, if a resolution is to be put forward, if a bill is to be put forward, then we can consider the quorum. But for the
Absolutely, Barrister Saab, essentially what Kakakhel Saab is saying is that, you are only interpreting the constitution, but there is also such a thing as rules of business. So that also applies in this case, and that actually essentially identifies what kind of a session is going to be there. But I wanted to, with your permission, Sana, wanted to comment on something that Barrister Shabbir earlier said regarding politics and this being a good move politically. With due respect, I was thinking that if he is going to talk about ethics, I won't be able to comment because ethics is such a double-edged sword. But politics is something that one can actually talk about. And the problem with PTI is that it has, since it was pushed out of power, done half measures. That means that things that look intelligent on the occasion, but later on they don't actually survive and they fail repeatedly. They had 2 or 3 master strokes as well. For example, the way they organized their voters on the election day, I think that was a master stroke. Similarly, when they nominated Achakzai as the presidential candidate, that was also a master stroke. But apart from that, this will not stand the test of time. So why actually prolong your own misery by depriving women and minorities the right to be where they are supposed to be?
Exactly. Sana, with your permission,
it ended on question.
Wanted to go towards Barrister Shabbir. Barrister Shabbir, let's suppose, supposedly there is a situation in which, of course, we are seeing that the Speaker of the Assembly, he actually, asked for a session, and in that session is just merely for one sole reason, and that is to, of course, the step that has been taken by the governor of KPK, they want to actually condemn that step, because for now we already know that the food minister of KPK, he has condemned the KP governor, and he has called upon him as someone who is an opposition leader rather than acting as a governor. So can we say that if that kind of session is called, and in that session, knowing that the situation in KP Assembly is that the legislature, the number of legislatures, they already have the right number to actually pass that resolution against the KP governor, what kind of situation we would be in at that time if the legislature itself passes such
doesn't
kind
matter.
of
Doesn't matter. But Barrister, my question in the end was not a rhetorical question. I also want you to answer, why prolong the misery when you know this is going to be the outcome?
legislature.
So why I've understood Raja Saab's question. What is your question, sir? The second one. Why prolong the misery for?
No, it isn't Raja Saab's question. I was saying that PTI, you were praising their political move. My humble submission was that most of the things that they have done, like resigning from assemblies, dissolving the assemblies, and then doing many other half measures that did not lead to anywhere. Right now, this seems to be the similar kind of case where you're only delaying the obvious. So why actually do it? Why prolong the misery? If the Supreme Court eventually overturns Peshawar High Court's decision, again, very likely scenario, but if that happens, then you can always come back and disengage from the whole process and demand some kind of remedy. But why do it now?
Because, sir, they don't have the same insight and wisdom that you have.
Come on. But go ahead, answer Raja Faisal also.
They are still hopeful and trying, they are hoping against hope. And I don't know, they are maybe trying their luck. They might think that someday they would get something. But like I said, they are not as aware. So coming back to Raja Saab, like Pitafi Saab said, absolutely nothing. The resolution would be of no consequence. The governor is there by virtue of his constitutional position. It's an appointment by the president. No resolution can remove the governor. It makes absolutely no difference to his health, nothing at all. So yes, but again, I think I read your question to mean that what if that is the only resolution which is passed and the other business is not attended to? Was that your question, or did I read into it?
Yes,
I
and
mean,
knowing the fact that the opposition already has gone to KP, High Court regarding the same case, that of course they want to have that session, but they are not able to, just because of one reason, and that is the government is not. KP government is not going for it. The KP Assembly.
I mean, uh, you can't do anything about it. If the speaker, who's the chair of the house, and the deputy speaker for that matter, uh, they adjourn the matter or they prorogue the session, you can't do anything. That's it. The session is adjourned. Even if the session is called and the session is adjourned, it stands adjourned. Yes, the High Court would take into account these steps, these acts, and they would be referred to as malefides on part of or these tactics, and then the High Court can be persuaded to grant an interim relief that yes, until such time these members are given oath, the Senate elections or the elections on 4th from the KP Assembly may not be finalized. I mean, in a number of occasions, the court has amended or modified the schedule given by the Election Commission. So I do think that they will not be able to get away with it that easily, because the Senate elections, this whole thing is being done for Senate elections, and the High Court can be persuaded to grant interim relief on account of this, that until these members take oath, the KP senators may not be, the seats may not be filled.
Right. Nouman, last question to you with regards to what has been discussed regarding how certain things need to be sorted in the political arenas and by politicians. And of course, unfortunately, the courts are moved in many issues in Pakistan. But I want to know, is it not in the domain of the law to ensure that whatever is provided as per the constitution, as per the law, is actually followed? And if it's not, then that is something also that provides the opportunity that the time frames or the guidelines or whatever sort of boundaries that exist within the law are actually followed, and if not, then there are guarantees to make sure that it does. Is that not something that falls within the courts, and how then will politicians take a look into matters like these when questions of whether or not something is legal arises?
And Kakakhel Sahab, it was Sana's last question. I want to add to this as well. Garnering from whatever Barrister Shabbir was saying. So the ideal situation for PTI in this scenario would be the depriving women and minorities seats or their oath, and then also depriving future senators to get elected on time. Is it what we are going to talk about now?
The first question.
You'll have to unmute yourself, sir. I think you are muted.
No, no.
Go ahead.
The first question was put forward by Sana, whether there are consequences with regard to what is not being done in accordance with law, rather violating the mandate of the Constitution and orders passed in accordance with law. So the issue here is that the Constitution have provided certain things, but there are no consequences, rather penal consequences provided therefore. So when we talk about such issues, then the debate comes with regard to parliamentary immunity, that the courts are not to interfere in the business of a legislative assembly. But at the same time, on the same hand, we talk of a trichotomy of powers, the checks and balances system. So the only thing that we can hope for now, or that everybody is looking forward to, including the opposition, is that they have to opt for the High Court seeking a relief against the Speaker of the Provincial Assembly that they have to call for a session in line with the orders of the governor of Khyber Pakhtunkhwa and let the vote take place before the election of Senate. Other than that, they do not have any other option since the judiciary works as a balancing element, rather a balancing body against the parliament, against the provincial assemblies. So this is the only relief that they can seek and the only place that they can knock on against the illegalities. I won't call it illegalities, but against not following the mandate of the constitution. Now,
Right.
Raja Saab, I believe Raja Saab had put forward another question as to what is the
Farrukh did.
Pitafi's out.
Okay, for the day I am also Raja. Please go ahead.
the best and the ideal situation for PTI for now would be that they try to seek an interim order from the August Supreme Court before the Senate elections or before the takes place before, because it's everybody's very positive that if the opposition moves the Peshawar High Court, they will get a relief within no time. They will get it in a few days, as the matter of reserved seats were decided in a few days by the Peshawar High Court. So that is what is positive about that. The best scenario for PTI, rather the Sunni Ittihad Council, is getting an interim order from the Supreme
All
Court.
right. Thank you very much, Advocate Nouman and Barrister Shabbir, for joining us
Thank
and
you
being a
very
part
much.
of the discussion and talking to us at length and giving us so many insights as to what's going on. We're going to also be focusing a little bit on what is going on with reference to the discussion around counterterrorism activities, particularly in cooperation with Afghanistan. And Faisal, I'd like your take in on this first. With reference to, of course, what has recently happened, this is not something new that we've been urging for the Afghan Taliban to do so. But in terms of the kind of limits that we have, of course, in terms of tolerating what is going on and in terms of being subjected to the kind of terrorist activities there and not having that reassurance from the Afghanistan side. Of course, just recently we've seen in the airstrikes that were carried out on the terrorist hideouts there as an absolute necessity, of course, in response to the terrorist attack on March 16th. What then will be the future moves with regards to the kind of cooperation that can exist from a side that has historically not really provided that?
Yes, and obviously when we talk about cooperation, attracting cooperation from Taliban regime sitting in Kabul, of course this is a matter which we have been highlighting since almost 2 years now, and the reason behind it is that of course these attacks, they were being committed in Pakistan and the territory within Pakistan, and they were originating from obviously their provinces. The cross-border terrorism was taking place, and time and again Pakistan reiterated the facts to Taliban regime sitting in Kabul, but they failed to, of course, pay any heed to it. This was the right time, right move to do by Pakistan side, and I think Pakistan has done an excellent job. And talking about the future, what stance Pakistan would be taking, Pakistan would welcome any talks which are of course initiated by Pakistan, and Taliban are becoming part of it, because eventually we have to of course negotiate peace, and negotiating peace, it requires the Taliban to understand the facts, understand the ground realities, and the ground reality is that the terrorist attacks are originating from within Afghanistan, and they have to deal with it out there. Pakistan, Pakistan does not want to, of course, infringe somebody's sovereignty or anything like that.
Right.
We just want to reiterate facts once more, that the attacks which are originating from there, they will be responded, and they will be, of course, replied, and the deterrence would be maintained on them lands, on them hideouts of TTP, BLA, BLF, whoever is being facilitated by ISIS Khorasan. And I think it's time for Taliban sitting in Kabul to know the facts and to, of course, make sure that their land should not be used against Pakistan.
Right, absolutely. Farrukh, the defense minister has also talked about the possibility of ending the trade corridor, and I want to know whether or not all of these strategies will help in actually ensuring the kind of cooperation we need.
Counter question, Sana. Do we have time?
We have a little bit. How much?
Okay. Well, I thought if it is 55 already, so I
can take
can
2
wait
minutes.
for another day otherwise. But regarding the overall situation, I think Pakistan will do whatever it takes to stop terrorism. But given that there was another terror attack today in DI Khan and 2 more security personnel were martyred, I think that on one side you'll have to keep up the pressure on Afghan Taliban and using all the measures that are needed or they are available. Number 2, you'll have to harden the border as much as possible, and it is not one-time affair. But you'll have to ensure that people don't sneak in. The third one at this moment, I think we need internal security organization also. Now that we have a very strong interior minister, it will be a good time to actually reorganize NACTA. And NACTA, that actually reports to the interior minister, and that ensures that there is the kind of intelligence sharing between agencies that we had originally visualized in the national security policy, so that anything that happens can be taken care of by NACTA and national counterterrorism policy.
Absolutely. Thank you, Farrukh. Thank you, Faisal, for joining us and being part of the discussion. That's all we have from the show. We'll now see you tomorrow.